Hi, ladies and gentlemen. We are back with the SAPI IP Business Talks. And before we start, I would like to say thank you for all of you who join us here. And this is a live show. That means you can ask questions or give comments here under the post of this show in the chat, and I can see that here, and I can pick that up and will pick it up and ask your questions to our guest. So our guest is Margaux Zyla, and we talk today about a very a hot topic, simply because obviously we are deep in the digital transformation, and digital business models are around us everywhere, and customer interactions are done with graphical user interfaces. And so the strategic necessity and the power of design protection was never as big as today. And so I'm very happy that Margaux Zyla is with us here. She's IP subject matter expert on the platform, and she will talk with us, explain, and also talk with you today about this topic. So thank you very much, Margaux, that you are with us today.
Hi, hello everybody. Hello, Alex.
Great. So, Margaux, my first question, all of our audience knows that my first question to my guest is always the same. How did you came into this strange field of IP?
I got in contact with the intellectual property law already quite early. I was in the time when I was still a student, and in a summertime I worked in a big law office in Warsaw. And I could participate, of course, as a role of a student. In the time, we had quite big legal infringement case in a alcoholic beverage sectors, and I was fascinated.
Vodka.
Yes, of course, absolutely. And it was the infringement concerning a lot of trademarks and also a design, a shape of a bottles, different bottles, and it was across a lot of countries, and I was fascinated, and until now, and I decided to work in this sector, and every day I liked my job because there is a mix of technology, the creativities, and the law. Each day, we like an expert can be the first one to see the beautiful creativities of our clients, and we try to support them. And the second aspect why I appreciate this sector is that I was studying in Poland law and also in France, and I live and work in Germany, and it had never be a problem. On the contrary, it's a big benefit because I think that this helps me to understand the different legal approaches and to understand my clients over the world.
Got you. Got you. Wow. So, I mean, we all share this fascination for IP. That is the inner force which creates also this community. So, what I would like to show. What I would like to show to our audience. So this is the Dplex page run by Margaux, and you see here the different topics which she is presenting, and this is really deep knowledge about all these different aspects on design protection, especially the new developments here. And we have also for you available, for the ones who want to make a bit a deep dive in it, we have also podcast episodes with her. So first of all, to you, Margaux, thank you very much for that content. And we see from the access numbers that this is really relevant content, and that people have questions, and that it becomes a more and more, let's say, strategic topic. So when when we say we would like, we would like to determine elements of a product which can be protected or should be protected with design rights. What would you say? Also, basically, we have this regulation that it has not to be functional, and but how can we distinguish that? So when is something functional and when it is not functional in terms of when can it be protected and when not?
Thank you for this question. It's a very good question. If you get already in your question, there is an answer, or perhaps a part of an answer, because you notice that some features are excluded from the design protection. Design protection means that I protect with a law the appearance of a product. However, if you look at the product, you can see almost all the products which have a technical function. Look at the chair. How many chair, different shape you can notice? A lot. It means that the product, if they have a function, it doesn't mean that it can be protected. If I see a product, at the beginning, I make a kind of audit of the features and the assessment of the features. And doing this, I have one question. Was this a feature as a result of aesthetic ground, or it must be, otherwise the product will not function? That's why it is a visual approach or rather technical necessity. And you make a lot of make an analysis of all details, all features. In the end, you have 3 groups of features. The first one, purely aesthetic, ornamental, the texture of a product, shape of a bottle. They can be protected like a design. The second group of features is hardly technical. I mean, they are strongly function-driven feature because the product must function, or perhaps they are illegal standards, or perhaps they are shape which have been standardized, like a charger of a smartphone, or perhaps the standardized plug shape which must fit the socket. A lot of feature. And the third group is the biggest one, which covers both the aesthetical and also the functional. And in order to answer to your question, we notice how much deep was freedom of a designer. And if there is still a place that the product can function, for example, the chair will be comfortable, it is possible to sit down on it. However, there is still a place for the creativity of a designer. Let's do it. Let's protect this product.
Okay. So sometimes we have already the first very tricky question, but before I give the floor to Maria, I have also one, or at least a comment, because I think where it starts to become tricky with is it functional or not, is that when something looks technical, but it isn't. Okay, so our example from the master program and the university diploma in IP management at SAPI, I use typically the Dyson vacuum cleaner, but also the grooves in the sole plates of irons. Okay, so there are grooves in it, and that looks technically anyhow, so that it kind of steering the steam right from the iron, but the steam don't care about these grooves. Okay, it goes out of the nozzle and that's it. So something which looks technically but isn't is a really fascinating interplay, a strategic interplay. Also, tire profiles. So somebody would assume that tire profiles are technically on cars, but they aren't. It is the arrangement of the lugs and grooves which is crucial for the function, but not the pattern. So this is just aesthetic. So what is your recommendation here? Should companies play that game? Does that make sense? Is it dangerous, so to speak, that something which should look technical could constrain the freedom of the designer?
Of course, if the function if the feature is dictated by a function, this is a problem. Yes. However, in one of the last judgment of the General Court, it was saying that the product had only technical function. It was no place for aesthetic. However, the designer could defend this product because it was saying that the technical aspect, the combination and the position has given the effect that it was almost original. It was giving something new. Of course, there are lots of judgment. Unfortunately, we don't have a lot of time to analyze of the aspects. However, the first approach is look at the competitors. If they found it already, another shape, it means another like you. It means that there is a possibility for the creativity.
Okay, that's a good trick.
This is the first approach.
That's a good trick.
However, take care about one thing. If you are the first one of the market with this technical solution and you wish to protect this like a design, do not fight too much different design using the multi-design application, because it can be turned against you, like an argument that you wish to monopolize these technical solutions. It is also one of the recent judgments in that sector.
Okay.
That's why I would like to say you that it can help you if there are alternative solutions. It's very good, but it is not only the one reason. In each case, it will be a place for a designer and for the idea, the effort of the creativity. And I'm almost sure that each case can be defended. And please file a design application, because the patent is of course, I can't say what is better, what is worse, because they protect different aspects of a product. However, they protect the same product, the same product, the same product.
Okay, we come to that. Just I have a very tricky question, and I'm curious.
I have a lot of tricky questions.
Absolutely, absolutely. Here's one from Maria Boisova-Weinert, and she's always the one with the tricky ones, obviously. So she's really deep in the topic. In sectors like consumer electronics or furniture, design freedom often depends on supply chains, standard component shapes, or manufacturing reality. So it is not that free what you can do. How do you see examiners and courts evaluating design freedom when the constraints are economically or industrial and not per se technical?
Of course, it is a very difficult question, because a lot of features must be standardized. This is a question. However, and of course, we cannot be sure what was the reason of a creator to do it. However, if we can prove that next to the technical solution, there is still some creativity, some wishes to create something additional, it is a place. You know, a lot of charger, they have only one part which must be like this, otherwise it will not function. However, each one, if you go to the shop, they give you another impression. The overall impression for each one is different, and this is small gap
Yeah.
between both, you know.
Okay, I got you. I got you. So, but that means as a guideline. So you said maybe there are competing products, and when these competing products are already in the market and you look different, despite of all other standards and technologies and whatever, that shows or proves that there is a certain yeah um, a, a, a dimension which we can use for aesthetics or creativity.
And of course, if there are lots of design of this sector, every small difference, it is a creativity difference, you know. And the second argue, I'm pragmatical, but you know, if you file your design, there is a presumption of novelty and individual character. The competitor has to prove that it is not done, and your product is technical, you know. That's
Okay.
why at the beginning, we are not sure at least how it will be the result, the final result. However, if you protect your appearance of a product too late, it can be really too late.
Yeah. Okay. Got you. Got you. So you already started to explain us, I think, something which is absolutely mission critical in the whole game. And this is that out there are kinds of trade-offs. Okay. So a lot of completely stupid and ridiculous trade-offs which are simply not true. So things like, should I go with my software for a copyright or a patent? So which is simply, that are completely different things, and there are different reasonings, different aspects of protection. So there is no trade-off between going for copyright or a trademark. And I think so you should think either in layered IP or in a portfolio of IP. And for the different aspects of a product, I think this is absolutely critical to think in that way. So, and which means for me, when you say when it is functional, you cannot protect it with a design right, but that means on the other side we should think about other kinds of IP which we could use. So what would you say, what is the role of design right, or design rights in combination with, let's say, trademarks, technical IPRs, especially when it comes to have a holistic perspective on that. For example, for branding, for brand impression, for customer decisions.
Yes, because the design law closed the gaps between these others kind of IP right. And I think that in each company, the teams of trademark patent should consider the design power, the protection, the power of the design protection. Because, for example, for a patent, protect a technical solution, structure of a product. However, it can protect the appearance of a product, and also look-alike copies. It's very look-alike product. They are not possible to defend using the patent law, and also the shape of a product can be also protected by a trademark, but it is very difficult because the level of the distinctivities, what is the arguments to receive the trademark protection, it's very difficult to reach. And with a design,
Everybody has a Coca-Cola bottle, right?
yes, but you know, a design protection, if you have your design protected and you use this bottle on the market, it can this can also works like a trade, because the publicum will know your product and will also indicate original the identity of the origin of this product. That's why also I think that we have the registered European design, and it is only I think, still very cheap, the protection in comparison to a patent and also to the trademark. And for design, if you submit a design application, you cover the shape of your product, the aesthetical appearance, over all the NISA classification. You don't have to pay the additional fee for each class in order your product be protected in each sector. For example, if you have a shape of a beautiful car, which you demonstrate at the beginning, also your protection cover, for example, a shape of a chocolate where is incorporated this design. This protection gate over the different part of the products. Also a toy, like a car, like a toy. Registered design covers also this.
You said something. You said something which triggers me. Okay, because it is really, let's say, it is difficult in practice. You said the patent and trademark whatever tralala team in the company should think about design rights. So, wow. To my students, I give them this nice picture where you have in the middle a smartphone, and around this smartphone you have all the different protected aspects, covered aspects by different IP rights. Yeah, a copyright, trademark, patents, whatever. So, and then comes my question: who exactly in a company takes care that this kind of portfolio around a product exists, and that this portfolio is anyhow meaningful for the exclusivity of the product in the market? So, what is your experience in that case? So, is it so that you have somebody in the company who is really in charge for creating that kind of IP based exclusivity? Because my experience is, when you talk with a patent attorney, you talk about patents, and when you talk with a trademark lawyer, you talk about trademarks, and that is very difficult to have this portfolio angle perspective on a product. So that's what is your experience?
And my experience is that the design law is very often forgotten. The people do not think about this kind of right. Sometimes they didn't even know that it exists. Perhaps in some extent they think that there will be a copyright which protects my product, and for that I'm not obliged to do anything. However, please be informed that to cover your product via copyright, the level to reach this kind of quality of the originality, etc., it's very high.
Of course.
Of course. And you have to prove that you possess the copyright. However, for design protection, you submit your product, file the request, and in 3 days you have
case in Germany, right? We had this case in Germany with these Birkenstock shoes, and they tried to find a way to claim it as a kind of popular culture or whatever, but they failed.
Yes, they failed. Yes. However, if you speak about this product, I thank you for this question, because I think I forgot to explain one thing. If you have all the features, you know that some products have to stay the same. For example, Porsche. If you buy a Porsche, you buy Porsche because they have a historical shape almost. And this is the reason why you buy Porsche. However, also during the time, the people want to buy something which is modernized, because we want to still buy a new Porsche. Perhaps I don't drive a Porsche, I want to notice that. However, they want to buy this Porsche, and the second one and the third one perhaps. That's why it is possible to protect Porsche also with the small changes, the small shape. However, don't file the whole product, because most of the features are already not new. That's why in this case, we look for the perhaps parts that we can still protect, which change it already. That's why also with Birkenstock, the shoes, also the Birkenstock exists a long time. It can be that the design protection expired already. However, you can still the new features which appears protect like a part of the sign.
Got you.
And
Got you.
and this is the case because copyright is they don't reach the level of copyright, and they have the already registered design has been lapsed. That's why you should even take care, and each small difference should be protected like a design.
I have another tricky question. So today is I don't know. It's the nerdy day, but again, an ambassador of the IP Business Academy, Vicky Townsend, comes up with a very tricky question, and I would like to try first to answer. Okay, from my understanding of design law, considering surface patterns, can these be protected by a design right if a magnifying tool is needed to appreciate the detail? For example, a surface pattern on a metal component where there is design freedom, so in the detail of this pattern, and the design is original and has individual character, but it needs to be very small to serve a technical function. So that is tricky, and I think there's I think it's called rapport. So when you need, for example, for liquids, for oil, and also for haptic of metal. So my answer would be, and now I'm interested what you think about my answer. The provision is that the customer has to have a visual impression of the design, and when this is not given, so a design feature under the hood in a car cannot be design protected because the customer cannot see it from outside. So, and with that logic, I would say when it needs a magnificent instrument that it cannot be seen with naked eye, it cannot be design protected. So, but I'm happy to get your answer.
The visuality, the visual aspect concerns the complex product and the component part of the complex product. I would like to tell you about, let's speak about the reform of the design law, because this question is really perfect
Brilliant.
to introduce this
This
subject.
great, Margaux, because that would be my next question. Brilliant.
Thank you. And the requirement whether the feature will be seen during each moment of the use is not a requirement anymore in this case. The point is that in the representation of a design with the filing documents, this feature should be demonstrated. This is the aspect. And of course, I should see in details all the question. I will not exclude it, protection. And one thing still, if there is at least one feature which is not dictated by the function, it is possible to protect this product. And the also very small feature that can be magnified during the filing. You have find a third, fourth views of the presentation, and to demonstrate in a bigger size how it looks like. It is not a reason that normally you will not notice this. However, and indeed, it have a different shape, and perhaps it's not dictated by the function. It will be possible.
Okay, got you. So this is the design, this is the EU design reform. So when will it be enforced? What is expected?
The law is already in force, but since December 2024. However, it is a two parts of aspects of different elements when they start to work.
Okay.
To possible to be applied for some elements like the letter D in a circle, like a notice of a design is already possible to use since May 2025. However, the biggest and the most important part of the new changes will start on the 1st of July 2026. And I strongly advise to be prepared for this possibility, which will give the design law, because now all the products which are physical, the chair, but also not physical, what means digital products, can be protected. And still more, the non-physical products which are not digital. So, for example, the lighting shows on the air, on the wall, it will be possible to also to protect all the lighting effects which are projected by the projector. However, you know that once the projector is switched off, the design disappears. However, it is possible to protect it. But the most beautiful things, I think, is all the virtual world which can be protected. All the also animation, movement, transmission, all the aspects can be protected. In the gaming, for gaming scene, or for example, all the graphical user interfaces for the animated icons on your smartphone. It's really something very important which will come.
Yeah, I got you. So, which means what the reform is doing, it is changing the question, what exactly is a product and what do we call a design, right?
Of course, because the law must be modernized, because the notion of product has changed over the years. Now you notice there are lots of products which exist in the virtual area, which are not really you can't touch them, for example, or if the light is switched off, you can't notice this anymore. The things which is important, for example, until now it was also possible to in certain extent to protect animation. However, you could do it by using a static view, up to 7 static view, showing the movement in the different aspect with the progress of time. However, now it will be possible to file the video file incorporating your design. It will be possible also to use a different kind of 3D technology to demonstrate the movement, and it will be not only the begin and the end of the movement, but this file will help you to capture the complete movement, each aspect of the transmission.
Yeah, I think that is so. How a button on a graphical user interface is behaving, so to speak. So the look and feel of a graphical user interface. I think that because that to a certain extent this is exactly the magic. Yeah, so that I can do something with a window or with a button, and how this thing behaves. For example, after I clicked on it. And that makes that makes all the difference. I mean, everybody knows that on a MacBook, how the windows are opened is completely different to a Windows surface, where the windows behave, let's say, boring.
Of course, indeed, yes. We will see still how it will be in details, because if you submit a video demonstrating your product, your design, it can be also the background, which should not be covered by the protection, because it can also limit the scope of your protection. All the details will come soon, and I follow the changing, and I can answer all the questions because I'm updated. I hope so.
Wonderful, wonderful. Yeah, I mean that what you say is that it can become even tricky to file the application, because you have to be sure that it is only the video, for example, shows only what you really want to protect, and aspects of your product which you don't want to protect, or that can limit the borderline of your protection. Is that correct?
Yes, because, for example, if you have a lighting show which you demonstrate on the street, what about the buildings? What about the nature aspects? If you show them, they will also be included in the scope of protection of your design, which can also limit the product if somebody copies this without this kind of aspects,
Okay.
without the buildings and other elements on the street. That's why we still didn't know, because it will come all the information with so-called secondary legislation. Perhaps it will be possible now to submit a description or a claims. We still do not know how it will be in fact. However, the multiple design application will be applicable, and in this case, I suppose, and I will support this idea to make one application with animation using a video, and the second one with a static view, because also the number of static view will not be anymore limited to 7. That's why also it gives you the good opportunity. And also there is no more, it is an abolishment of the one class requirement. That's why for the multiple design application, that now you can use to protect different products using the same application, and to save your time and administrative task, and also the official fee, which is very important aspect of this application.
Absolutely. So what is now, okay, so that starts to be quite complex, right? So when when
Maybe.
when I think about all these, I mean, it took us years to explain to the software developers that that apps can be patented, because as long as these software is solving technical problems, it is obviously a technical mean, because you have to upload it to a computer. So where's the problem? But now comes on top, and then we have these brand representation, which I discussed, by the way, also with Maria she wrote a paper on that on the blog, for the logos, for example, that you should go for trademark protection for the logos when you do that right. But now comes a completely different layer. I don't want to say on top, it's anywhere in between, that the way how these app and how the objects in the app behave. You talk about transition, so how they move or transform into a new form, so that this is protectable. And
Yes.
and your recommendation is, especially, you should go for protection here, because at the end, so I had a long discussion with a company which makes pumps, Vilo. We have 2 case studies on Vilo, and one of the cornerstone is that there is a knob, okay, and this knob, the designer told me this knob is crucial. Why? Because you can touch the brand. Okay, it's a physical knob, and you can press it and turn it around. So, and what the designers of that graphical user interface has told me is that it is so important what happens after you clicked, because here you touch the brand, you clicked something, and now you expect a certain behavior. And this expectation, the customer expectation, is learned. Yeah, so I know what happens when I click on a cross on the upper right corner of a Windows window, I know that then the window will be closed, and this is learned. And so this is a strong customer. Yeah, this is a brand representation, how these objects move and transist on the screen. And what I understand, what you say is this is really a cornerstone of an IP strategy, that you own that. So that is a kind of, you own a piece of the brain of your customers.
Of course, because the new definition of a product about which you spoke about at the beginning, it is that you can protect your product which are completely different at the end of the stadium, because at the beginning, perhaps it was a free drops, and in the end you have a bicycle which is created of that, That's why, because the animation is the all the change what all the things what happens with the product, and also perhaps the video can be also used for the product which are physical product, for example, of a new collection of the shoes. However, if you present it on the video, you can see each details of the shoe. You can demonstrate it. Until now, it was possible to find 7 views, and I don't think so whether they can really demonstrate a 3D products, the 7 views. We did this, of course. We looked for a different possibility to protect all the details. However, with a video,
Margaux, at least we can show the red soles, right?
Yes. However, now I think nobody should forget about the design law and the possibility given by filing a design application. And in a lot of company, this aspect is not treated, and they come to us when, in case there is already an infringement, and if you have not a protection for the appearance of a product, it's quite difficult. Of course, there is a still small solution. This is so-called non-registered European design. However, you should demonstrate it that you are the owner, that you published your product, and the copy of a product must be identical. I mean, your unregistered design protect only against identical copy and protect only for 3 years. Registered design give you the protection until 25 years, which is longest like a patent.
Yeah, of course. And this unregistered design that goes into the direction of unfair competition, and this is a very, very tricky field, and typically
the way is very difficult to obtain, to use.
So compared to file a solid design right, this is really no comparison.
And at the last, perhaps I can tell you that there is a grace period concerning the publishing. That's why your design, once he was published, you have still 12 months, 1 year to protect them.
Okay.
And this design is still new.
Okay, good. Thank you very much. So that was a fascinating discussion, and I have hundreds more questions, especially when it comes to this interplay between physical goods and digital goods, and the digital representation of physical goods and all that kind of stuff. But for the moment, we are done. Thank you very much, Margaux, for your expertise on that a tricky and fascinating topic. And to you out there, Margaux is subject matter expert on the IPBA Connect platform. We work with her. We try to spread the word out there for exactly that fascinating topic, design rights, as an example of one of all these different IP aspects. And I agree 100% with her that we need much more awareness for this kind of topics. And when you want to become a subject matter expert here on the platform, get in contact with us. We are happy to work with you. And we will be back at the 10th of December, and then we had to postpone that discussion with Bastian Best, but then we will talk with Bastian about this flood of new invention disclosures, which are completely AI generated, and what that makes with the work with inventors and with the patent system. Margaux, thank you very much for taking the time, and I wish you a wonderful Advent time until Christmas, and strong nerves to survive.
Thank you very much, Alex, for this invitation and for the nice conversation.
Thank you. Bye-bye.
Bye-bye, everybody.